court could maybe reconsider its decision in its sentencing, knowing that Mr. Green is going to be getting the help that his family wants to offer, and that they would love to have him come up there to Texarkana, but they do understand that he needs to be admonished and punished and has to take some responsibility. And they're not trying to obfuscate that, and they're not asking the court to ignore that. They're just asking that if the court would to follow the plea agreement, that they believe that they would be able to be in a position to help Mr. Green once he is done with his sentence and can be back with his family in Texarkana, hopefully to get him back on his feet and assist him in any other way possible, as not just being his family in present, but also being someone that he can rely on and not have to.
Do you have proof of his mental health issues?
I do not on me at this time.
All right, so this is what the court is going to do. The court sentence will remain to guilty, revoke, taking consideration 2025 CC 007955, 14 months in the state jail facility, give you credit for any time served in the therapeutic community. If your counsel brings proof to the court of mental health issues, proof to the court from your family of some sort of plan, then the court will reconsider if the state has no objections. And I say if the state has no objections because there truly is no legal motion that's a motion to reconsider. Once the court enters a legal sentence, that legal sentence stands. So the state would have to agree to allow the court to reconsider. Do you understand?
Yes, please.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes.
All right. Thank you. And when do you anticipate having that information?
I will get it to the state if I can before the end of the week.
All right, then you need to speak with Ms. Ferguson about putting it on the docket for a motion to reconsider.
Yes, Your Honor. Thank you very much.
Donna Ellis,
Yes, ma'am.
Yes, Your Honor.
if you'll come forward, please. All right, what is happening with this case?
Judge, we have a plea agreement worked out with the state. However, I need to obtain some additional information from my client. She does have it in her cell at the jail, some timesheets and some judgments. So I intend to go there within today or tomorrow.
Okay, so if you have an agreement worked out, why can't you do the agreement?
We just need to get those timesheets to present to the court, Judge,
Timesheets for?
for time that she has spent in custody, Your Honor.
Oh, they'll be able to look that up.
I don't believe that they saw the reflection when I was speaking to the staff.
Well, I can tell you, if you enter a plea bargain agreement, the court is going to grant you legally, I must grant you any time that you served in custody. And if there is something that you feel as though you're not being given credit for, they do a nut pro tunc to make sure you get your appropriate credit. All right?
Okay.
So if y'all will complete the agreement, please.
All right, Judge.
Thank you.
So the court wants to go forward without having
Yes.
the proof to that? Okay.
All right, Eric Wayne Mason. All right, so your attorney is out ill. I don't know when your attorney is going to be available. So it may be best, yes?
Yeah, we're expecting her back within a month, Your Honor.
What, this month? So you have a choice. You can either continue with.
Right here, the judge draws a firm line between empathy and law. A guilty plea ties her hands. She must follow sentencing procedure, not personal emotion. But listen carefully, she still leaves a narrow legal window open for reconsideration.
This attorney, but what I can tell you, if your attorney is still out and unavailable, there's going to have to be a new attorney appointed because these cases have been around for a while. Do you understand? So here's my question. Do you want this case reset? It'll be reset later this month, and that attorney will have to appear, or would you like another attorney appointed to represent you? It's completely up to you.
Would be my claim, so I want. I believe the max is some way to punch another.
Yes.
Yes, that.
But it would also have to be said.
No, I mean, we'll get you an attorney here today.
Okay.
So what would you prefer?
For today.
All right, just have a seat. We'll make sure you have an attorney today. All right, thank you.
Thank you very much, Your Honor. May we excuse?
Yes. So anyway, sometimes you have cases, maybe attorneys are out ill, maybe attorneys don't show. And normally attorneys are not reappointed. But if somebody maybe hasn't spoken to their attorney in a while and they say they haven't spoken to their attorney for a while, or sometimes there are conflicts, then what will end up happening is a new attorney will be appointed to the representative. Because otherwise, cases will be on the docket forever, and we can't have that. And then we have motions to revoke. So motions to revoke, those are, well, let me back up a little bit. Anytime somebody does a plea agreement with the court, that's a contract. And so when somebody is violating that contract, that becomes a motion to revoke. So here on the criminal side, when a contract is violated, it's a motion to revoke for pleas. And so with contracts, like you learned in school with contracts, it's the four corners of the document, right? Well, it's sort of the same here. And parties can't agree really what a sentence will be because the contract says what it says. Now, sometimes as a judge, you can go outside the boundaries of the contract if you're going to sentence somebody to less than what they could have received. So sometimes you'll see that happen. Sometimes you'll see parties, hey, judge, we would like for you to give this person a year in the state jail facility or 5 years instead of life. You know, you take that under advisement, but if somebody's placed on deferred adjudication for a first-degree felony, the contract says if they violate that contract, they're looking at life in prison. Now, parties can come before you and say, hey, judge, we think they should be revoked. We agree they should be revoked, but we don't want you to sentence them to life, even though the contract says you can. We would prefer 5 years or 6 years, but they're really not allowed to enter into the plea bargain agreements at that point because the contract is what the contract is. This is a light docket. Yes. Usually we have about maybe 60 people. And I'm like, why is this docket light today? I don't know. So let me show you. We usually are in jury trials on Tuesdays. Tuesday afternoon, we do jury selection. So
This is the reality of the justice system. Sometimes it's not evidence or guilt that delays justice, it's scheduling and sick days. Courtrooms aren't just about laws, they're about people, and people get sick, busy, or burned out.
and this docket may change. This is the docket for Tuesday and Thursday. So everybody on that docket is to appear in court. Sometimes you'll see where it says somebody's in federal custody. When people are in federal custody and they have pending cases, they will not send them to state court until that gets completed. Now, on the federal side, of late, their cases have been set into the new year. So there's nothing I can do with my case because they won't bench warrant them over. They're not allowed to until that case is finished. They don't allow them to zoom in, so we're just stuck. All right, Maria Cisneros, come forward. Hello, how are you doing? All right, so anyway, as I told you before, you've had your chance to have everything worked out, so you're not allowed to homeschool. I want my daughter with charges to homeschool. So, and I understand sometimes finances are a certain way, but based upon what she's charged with, if I continue to allow her to homeschool and something were to end up happening, that's on me. And I know you're probably thinking, well, nothing's going to happen because that's my mom, right? And so I understand, and I understand finances are an issue, but part of my job as a judge is to protect the community, and I protect the community if somebody's on bond by setting specific bond conditions. Now, what I can tell you is her attorney states that he's not going to be able to be here today. He can put it back on the docket if he wants to put it back on the docket, because he has jury duty on the federal side. And on the federal side, when you have jury duty, if you don't show up for jury duty, they send the U.S. Marshals to pick you up. So he wouldn't be able to be here anyway. And if he were here, the U.S. Marshals would come pick him up and say, you have jury duty. So for now, I'm not going to allow her to homeschool. All right. So make sure that doesn't happen. And here's the thing. If that ends up happening, and if the police or somebody discovers it, say, for example, something that happens at your home where the police are called out. Could be something simple, like they're investigating something at a house next door and they want to talk to you. They're going to see, because her name is going to come up when she gives them her name, they're going to see that I have conditions in there. And if your children are there, you know what's going to end up happening. They're going to call you and they're going to call Child Protective Services. And then her bond's going to be revoked and she's going to end up in custody. And she's going to come back to here and want to explain to me why she violated my order. You understand?
Yeah.
So you're not allowed to, okay?
Okay.
All right. So what we're going to do is we're going to reset you in November so that you'll have a setting date.
Okay.
And if your attorney wants you brought back sooner, he'll let us know. But I'm giving you the November setting so you'll have a set date where you know we can come in and address this. But he may have you in early. It just depends on what happens with this jury service over there, all right?
Okay.
All right, Ms. Ferguson, what day in November is good for you? Do you want the beginning of November?
Is the middle or?
Well, I mean, do you want it heard as soon as possible?
Just whenever. Whenever best for you.
No. I'm here all the time.
Oh.
So we can put it that first week in November. All right, I need the beginning of November recess.
This exchange is so human, a mother asking to homeschool while facing criminal charges. The judge isn't being cold, she's weighing safety versus sympathy. Would you, as a judge, take that risk?
Set November 3rd. All right, so we're going to call you back on November 3rd. Make sure that you're on time, okay?
Yes, ma'am.
And thank you for dressing appropriately for court.
Thank you.
Once you sign the reset form, you'll be excused. And thank you for coming in.
Thank you.
Thank you. All right, Jesse Lutzenberger. And where's the other attorney? He said he had a plea. Oh, he's going over paperwork. So this is a plea bargain agreement. The court is calling 2025 CR 003-507 State versus Jesse Lutzenberger. Can I have parties announce?
John Whalen for Jesse Lutzenberger.
All right, excuse me, in the box. You all need to lower your voices. And are you Jesse Lutzenberger?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lutzenberger, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
And now a whole new case and a whole new energy. Watch how the judge switches gears. This next plea might seem routine, but every yes and no locks Jesse into a legally binding decision that could shape his life for years.
Yep.
That's either yes or no.
Yes.
All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Seeing on the front pages of this whole language.
Any objections?
No objections, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? No. Did you review this document? Did you understand it?
Yeah.
Did you sign it in all the appropriate places?
Yes. No.
The state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. The range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Luxemberger, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported and denied naturalization and denied re-entry into the United States. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
Notice how the judge completely shifts tone here. New defendant, new energy, but the same precision. Every yes and no locks Jesse into a binding legal contract. This is the calm before the storm.
To the plea, the state is proceeding on the lesser included offense of assault bodily injury. There's a $500 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yeah.
That's either yes or no.
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Mario Montemayor, and the hostility management course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
In upper states,
No objections, Your Honor.
All right, and state, have you had a chance to speak with the complainant?
yes,
All right, thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, yeah.
Anything you wish to say on behalf of your client?
Just that we wish that you follow the agreement, Your Honor.
All right, what were your issues that day?
Were my issues with this?
Yes.
Well, I couldn't believe it was happening because all I wanted to do was go vote.
No, the problem was not you going to vote. And I will tell you, I teach campaign and election law. And when people at a location tell you that you're not allowed to wear certain items when you go into the voting booth, you're not allowed to do that. When they tell you you're not allowed to wear certain items when you're entering doors, you're not allowed to do that.
They told that it wasn't posted anywhere, and the people that were working there didn't know themselves.
No,
They
that's the
wouldn't
law.
tell me that.
I'm telling you, that's the
Well, I'll
law.
tell you, I didn't know, and other people didn't know.
Well-
I'm explaining my situation. That doesn't seem that anybody's heard yet.
Oh, well, let me just tell you what it says in here in the police report, because maybe you didn't read it. It says you were walking in and the person, they have judges who are there for voting and they have people who are working there, who work there. It's yes or no. It's not They were working there and they told you you needed to remove your hat because it was not allowed inside the voting area. And that's the law. And that's always, but here's the thing. That's the law. It's always been the law. For example, I can't walk around with a t-shirt with my name on it saying vote for me and go in the voting booth. It's not allowed. Once you get to a certain point and it's that 100-yard line that they have, when you cross into that area, you're not allowed to be in line with t-shirts about who you support. You're not allowed to do that. That's the law.
And here's where things explode. The case flips from legal routine to raw emotion. A man defends his hat, his rights, his pride, but in court, emotion rarely wins over law. Watch how the judge reins it in.
Then when people tell you that, you can't start hitting somebody. And it says on here that your wife even tried to stop you.
Ma'am, that's all incorrect. Do you want me to explain? Can I explain?
Sure. And if you want a jury trial, I'll give you one.
Well, I'm not talking to you, I just want to explain because it's incorrect what they're saying. I was in line for 45 minutes before I actually got to vote. They asked me to remove my hat then, after I was standing there for 45 minutes. So I removed it, I put it in my lower back. I went through the whole voting situation. When I went out the other side, this person that had already harassed me in 2 other previous times that I went to go vote in a different location was again there. I walked away from him twice, 2 other times, when he was verbally harassing me. Okay, this is the 3rd time. And this 3rd time, I walked away from him again twice. He would not let me walk out of that place without harassing me and getting physical with me.
All right, so
That's what my wife was trying to.
let me tell you what it says in here. And I go by this document. It says that the complainant went on by explaining that as part of his duties, he is supposed to advise voters that they are not permitted to wear or display candidates on their person while they are on the polling premises. It says he observed an older adult male inside the polling premises, and you had displayed campaign material, which was your hat. He observed the violation. He contacted the male and advised him that he would need to refrain from wearing the hat while on the premises. The complainant explained that the male complied with his instructions while he was voting, but then put the hat back on as he was making his way to exit the premises. At the time, the male was still inside the building and clearly well within the premises. Due to still being well within the premises, he approached you again and advised you to remove the hat while he was on the premises. The male, that's you, explained that he was on his way out and refused to comply. And it says, he began to follow you and told you again to remove your hat. And as you were about to exit, you struck him on the chest and facial area several times with your fist, causing him pain and discomfort. And then it says, another witness and your wife began telling you to stop. And then that's when you left. I don't know why when people go to places, how hard it is to follow instructions. When they say you can't do something, you can't do it. And if you want to complain about it, complain to your legislature. If you want to wear campaign materials inside a location while you're voting, if you want to wear it within the 100 lines, because they have those lines marked with a white, sometimes yellow line. If you want to do that, then you need to write your legislator and say, look, you need to change these rules because I want to wear my campaign gear inside the area while I'm voting. But for now, you're not allowed to do that. And you need to follow the rules. How old are you?
4.
All right, you're 64 and you're up here fighting and I don't even call it fighting because it doesn't say that he ever even hit you back.
Yeah, of course.
The judge softens here, and that's powerful. Even after a heated case, she turns it into a teachable moment. It's not just about punishment, it's about understanding why the rules exist. That's courtroom wisdom in motion.
And so you're up here fighting with somebody who's just trying to do their job, help people come in and vote and go on your merry way. And they're not even paid enough money for somebody to be hitting on them. So it appears to me you do have anger issues.
No, I don't have anger. Like I said, I walked away twice. And in the situation, I walked away because didn't say anything in there where he followed me all the way and he screamed in my ear. I have hearing difficulties from my time in the military. I didn't hear what he was saying. I was walking out and he was quite a ways.
Did he not tell you to remove your campaign gear?
No.
And that you were not allowed in the area?
That was after the fact when I had already gone out. I was in the library section already.
let me just tell you, within that 100 line, you are not allowed to wear campaign gear. Now, if you're saying what's being said is untrue, then you need to set this for a jury trial, because I go specifically by what's in the police reports. And there's a reason why this says waiver consent to stipulation of testimony and stipulations. You know what that means? That means that everything is in this document. You're stipulating that it is true and correct. And this is what it says. I, Jesse Lutzenberger, do hereby judicially confess and admit that I intentionally and knowingly in Bexar County, Texas, on or about the 24th of October, 2024, did intentionally and knowing cause injury to the complainant by striking the complainant with the hand of the defendant and by pushing the complainant with the hand of the defendant. That's, you stipulated to that and said it's true.
Anything about him punching at me first?
What I'm telling you is you're saying this is true. You stipulated to this. Now, if you're saying he punched you first, then maybe you want a jury trial and you want to say it's self-defense.
It's on video. The only reason why I'm accepting that is because I don't have the money to continue. Or of course I would defend myself.
All right, does he want a jury trial?
No, we're accepting the plea bargain.
Oh, is your wife, is somebody here?
My wife is here.
Oh, she said, no, you don't want a jury trial.
Okay, no.
All right.
Your Honor, if I may, I believe that, look, point being, there's, as you stated, that's completely clear. The law is the law. I think that there was a fundamental miscommunication and understanding as far as how it was proffered to him at that time. I think that realistically, the way people speak, someone told him, take off the hat while you're voting. I think in his head, that's what he believed. Hey, take the hat off. I'm walking out the door. I'm basically at the double doors. I can put the hat back on. Understanding clearly that is still in violation of the law. But I want to make clear, it's not like the statute book was not pulled out and read to him at this time to understand the 100 feet. Again, it's not an excuse, but I think where his mind was coming at, he had finished voting, he had waited the 45 minutes, and he was leaving, and then he had an individual come up and approach him. Just to give some context, it's not change, obviously, the law itself or your viewpoint of this, but I want to...
Well, I mean, my viewpoint is the stipulations that I received.
Understood.
All right. There's going to be a $500 fine, 2 years deferred adjudication, 200 hours of community service restitution, proof of employment within 30 days, no employment as a home health care provider or with minors. There's going to be the hostility management course, regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 6 months. And there's to be no contact with Mario Montemayor. Probation, is there anything else?
Judge.
Is there anything else you need from the court to be successful?
No, I would like to say that all this is my self-defense. Because nobody wants to be harassed or bullied in front of their significant other.
Yeah. I understand. You know what? I understand what, here's the thing. I understand what you're saying. And I understand sometimes that tempers run high, right? And sometimes when we don't know the law, and if somebody just tells you, you can't do that, sometimes people want to know why I can't do that. And they want you to explain it. Sometimes people will explain it. Sometimes they will not. For example, I try to explain everything so people will know why things are happening. So now you know, and I'm telling you, yeah. So here's the thing. This is what I'm telling you. When you see, if you go vote again, when you see that line, you are not to cross that line with any campaign materials. And that's why when you see candidates who are out there talking to people, they're not allowed to go past that line. You know why? Because you are not allowed to campaign past that line. And wearing T-shirts or any type of hats or anything for whatever candidate you support, whether you say anything or not, that's considered campaigning. And legally, you're not allowed to do that. And if people want to change the law where they can wear their campaign shirts or whatever beyond that line, you have to do that with your legislator. My job is just to follow the law. You understand?
Yes, this happened in Georgia and it happened in South Carolina, I think, and the people still got to go and went on their ways.
Well,
Different ways, like,
this Texas.
Yeah.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes,
All right. Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes, ma'am.
All right. Ms. Abrams will speak to you.
Okay.
All right. Thank you.
Thank you, Your Honor.
You're welcome.
First one.